This podcast contains content that is graphic in nature and mature language that may be unsuitable for children or young listeners. Listener discretion is advised. Hey, CenLAw fam. I'm Kelly.
I'm Kyler.
And we're bringing you guys another update episode. Lucky you. I told you on the last one that I wasn't sure what day these would fall on. This one just so happens to fall not on a Monday. So, sorry about that, but you're also welcome.
Today is Monday.
Yes, but we're recording it on Monday. We're not going to release it until...
Yeah, but it still fell on a Monday.
Okay, close enough. All right.
Counts.
So we're recording on a Monday.
Counts.
Still counts. Okay. So we've got a really awesome update for you guys, and this is really exciting too because this is the second off week in a row where I've found an appeal for one of our cases that literally just got decided this year within the last month. So we've got another appeal update for you guys, and this one is going to be for episode 11, the senseless shooting at the Sugar Shack, and senseless, we love an alliteration. So
even during the alliteration,
if you haven't listened to that episode, go do that right now and then come back and listen to what the appeal ended up being. So we're gonna,
because otherwise you won't know what the hell we're talking about.
well, we're gonna short summary it.
Otherwise you won't know what the hell we're talking about.
So just real quick though, just like we did last episode, I'm gonna throw some stats at you guys because I don't know what's gotten into our listener base here recently, but you guys are amazing. Other than the fact that we don't have any new reviews. Other than that, you guys are amazing. Just for November alone, I told you guys you had to step it up because we had to get over, I think it was 192 episodes that we had, or downloads that we had in October. We had to beat that to, be better than October. And as of today, November 13th, we already have 119 downloads for this month. So in 13 days, not even 2 weeks, we've got almost 120 downloads.
So y'all are killing it.
You guys are absolutely killing it. We actually broke the 500 download mark.
I didn't break nothing. It wasn't me.
On the 2nd of this month, on November, a week from today ago, we broke 500 and we're already over 600. So just in the last week, we've had over 100 downloads. So you guys are absolutely killing it. Thank you so much. Keep listening, keep telling people about us. And if you're on our social medias, like, share, all of the fun stuff. And if you have a minute, leave us a rating and a review because that helps get our podcast up into other people's feeds and other people can
all up in their business
listen to us and join the base as well and give us that recognition, which is really awesome. Plus I really want to tell about interesting or fun ratings, even if they don't have anything to do with a podcast. I would love to be able to read goofy stuff on the next update episode. So unfortunately, as it stands right now,
what she's saying is if you want something to be read on air, doesn't matter what it's about.
Exactly.
Just write it in a review.
Write it in a review.
Make it a good one.
And I will read it.
And it will be read
out loud. Yes, I will. And until that gets to be overwhelming or overbearing to the point where
we're not talking about you.
To the point where it's going to be too much to put into an episode if we have 20, 30, 40 reviews in one setting. That's not going to happen. I'm going to pick out the best ones, obviously. So make it a good one is all I'm saying. But for right now, just do one. So there's that. I don't think we have any really crazy updates when it comes to locations and things like that. As far as I can tell, it's pretty much staying the same. We've got Mexico, United Kingdom, Philippines, Australia, France, India, Ireland, which I think are pretty well all the same. Dallas still at the top, and then Louisiana pretty much dominating for the first top 6 or so. And as far as
we might need to clarify that we don't think that France, India, and Ireland are all pretty much the same.
No. I just mean that they're the same that we mentioned in the last update. That's my bad. I don't think there's any new locations to mention that are new as of the last update episode. So
absolutely.
Other than that, keep listening, keep downloading, keep talking about us. We actually had our very first email listener recommendation for a case, which I have already ordered a
Nice.
book on Amazon that should be here.
Oh, it's that one you were talking about?
Yes, it should
Nice.
be here either Wednesday or Thursday, I think. But
Oh, yeah,
I
that's
ordered that
cool.
book because I'm very interested. I'd never heard of the case. It's an older one, I think, from like the 80s. But I'm really interested. It's going to be a really awesome case. Can't wait to cover it. Thank you for the suggestion. And I am looking forward to future suggestions because if they're as good as this one, I cannot wait. Super excited for that. So, and I'm hoping at this point you've either gone back and listened to, or you have already listened and then come back and now you're weeding through all of the stats to be able to get to the appeal part of our update. And so we're just going to jump right back in. So our episode 11 covered the murder of Dejon Mitchell, who was attending a party at the Sugar Shack in Jonesville, which is in Catahoula Parish in Louisiana. And they were, the Sugar Shack was hosting a DJ known as DJ Young and Gunnin, whose real name was Jordan Johnson. Yeah, it's a lot. So Jordan Johnson was the DJ that was having a party at the Sugar Shack in Jonesville. They were apparently not in as festive a mood as Dejon Mitchell was. He was being a little rambunctious, dancing, enjoying, vibing, and enjoying himself.
Turning up.
And he bumped into either Jordan or one of his crew that night, and things got out of hand. Fists got thrown, and then, according to
And then metal got thrown. Really
everything that we went over in episode 11,
fast. By a gun.
Johnson pulled out a gun, and according to the court documents from the appeal, said he was shot 6 times, 5 of which were fatal. And I think when we talked about it on the episode, I wasn't sure if it was 5 or 6 because of the way the autopsy read. They weren't sure if it was a through and through, so it wasn't sure if the one bullet had caused. Yes,
Okay.
They weren't sure if the one bullet had caused the 2 sets of damage or whatever. But either way, he shot 5 or 6 times.
I
Killed
remember that
him.
confusion. I just didn't think that was this one.
Yes, that was this one. So he fled, and then they used Project NOLA cameras to be able to track down the vehicle by the license plate tags, and from the Instagram posts and everything, they tracked down the car, tracked him down to the apartments in Natchez, and then were able to live stream the feed as the SWAT team moved in to arrest him, which they did without incident. Later, they found him guilty, I believe it was in 2021. Or no, it was actually the beginning of 2022 when they found him guilty and sentenced him to life.
It was almost exact.
Right, exactly. Yeah, it was almost to the day. He was found guilty on December 15th. He was sentenced on January 25th.
Okay.
So all of that, it was exactly 3 years, 19, 20, 21, yeah, 3 years to the day of the shooting that he was found guilty. He was sentenced in January, and they added an extra 20 years because he was a felon in possession of a weapon. So he was sentenced to life without parole, no benefits, second-degree murder, also tacked on 20 years hard labor for the firearm. So, according to his appeal that we now have, that was decided on November 2nd of 2023, so just 12 days ago. They appealed his conviction and sentences. Now, there were 2 separate appeal things filed, which is, the reason I say things is because his counsel filed an appellate brief asserting 2 assignments of error, but he also filed a pro se brief, so he filed one on his own as well as his counsel filing one for him. So the 2 errors that the counsel filed for was that the trial court erred in excusing a juror under one of the criminal procedural statutes. And then they also say that the trial court erred in failing to grant the defense's motion for a mistrial, or if they didn't mistrial, then they needed to dismiss said juror. Now, we'll get into that in a second. I'm going to go over the pro se brief errors and
Pro se.
because they were really kind of goofy. Okay, honestly, one of them, he tries to say that there was a lack of jurisdiction. Now, this isn't the one he filed himself. So Jordan Johnson, outside of his appellate lawyers, filed his own appellant brief saying there were things wrong. So in his, he said, and they only addressed a couple. From my understanding, there were many, 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 but they picked out the ones that actually had any kind of maybe a weight to them. So one of them was that they had a lack of jurisdiction, because according to him, he said that the state of Louisiana court has nothing to do with the case. Even the appellate report says, quote, "It is unclear from his brief why defendant thinks that Louisiana lacks jurisdiction or why he believes that this should be a federal matter," unquote. So they were just as confused as I was when I was reading it. No idea why he thought it might be federal. So
Across state lines, maybe?
I don't know. Maybe. I'm not sure, because it's not like he kidnapped somebody.
Right.
So there doesn't make any sense. Another one of the errors he said was, okay, this is where it got kind of goofy. The state court lacked jurisdiction because he's Native American. Now, the appellate court said, quote, "We address this assignment here because, like the previous assignment, it asserts the state court lacked jurisdiction, but the defendant cites nothing in the record to show that he is Native American. In fact, he does not cite a record at all in this portion of his argument." So they had no idea what the hell he was talking about. Like, where did it come in that he was Native American? Where did that play into any kind of part? And he even, they're saying that he didn't even make any pretend notion as to why he even brought this up. Like, he didn't even put any evidence or anything into his brief to say as to why he thought this was important or why he thought he was Native American. Like, it's kind of mind blowing.
He was native to America.
Okay,
Jesus.
maybe, I don't know. So
he's a sovereign citizen. You can't touch him.
maybe. So one of the errors that he did actually argue that is normal that we hear in the appeals is the sufficiency of evidence. Now, they go through a whole bunch of other stuff saying there was a whole lot of reason for all the evidence, not just the eyewitnesses, but all of the other evidence they found on him in the vehicle at the time of his arrest, all of those things. And, they just basically said, "You are not doing a good job here, sir." So moving on from that, they just said, this shouldn't be a federal case. There's no reason it should be a federal case. They get into more nitty gritty about the things that he was citing, which had absolutely nothing to do with his case. Something about the protection of children, which also didn't make any sense because he's not a child. Just a whole lot of, I have no idea. I think he might have got in touch with one of the, I don't remember exactly what the term is they use, but they're incarcerated attorneys. So the guys who go, they write a lot of these appeals, they write a lot of motions and things for people who are in there because they've been in there for so long. They have a pretty good idea of the law at this point, and they don't have anything better to do with their time, really. So they help other inmates write motions and appeals and things. And that's my guess, is he got in contact with one of those guys, and this guy just kind of went wild and figured, this is my time. I'm not sure. So, having said all of that, they pretty much dismissed his pro se brief, and then...
I was just saying, it's also fully believable that the things that he wrote could have, an air of truth to them, to where... I don't understand the protection of a child one.
Yeah, but, I don't know.
But maybe he does have a Native American in him, and he knew, I can get a scholarship for that. I can get a grant for that. Maybe I can get out of maybe I can get out of jail for that.
Well, no, and that is the thing. Like, if you were Native American, you actually have a right to be tried in your tribunal, whatever. But at the same time, he provided no actual evidence of that. He made no other argument towards that.
He may not also, but he may not realize that he's supposed to.
Right, and maybe that was it.
That was in the pro se one.
Right, for sure, and that's all very possible. So,
but he sounds like he was trying real hard to get out of everything without giving any good reason as to why he should get out of it.
Right. And so basically the assignment lacked merit in all of the assignment of error, all of them that he tried, they just lacked merit, and they closed the book on his pro se brief. So
the moral of that story is unless you actually have learned some of the law, Don't write a brief yourself.
Right,
get somebody that knows what they're doing to do it.
Right, and in most of these cases, the appellate lawyers are paid for by the state. Those are given to you, especially in these life without parole sentencings. They are basically like a public defender for the appellate court. And so if they're already doing all of that work, and like the only thing that you can do, and in my opinion, and I don't know if other attorneys, or I'm not an attorney, but that's what I mean. You know what I mean? If others would say the same, like, I feel like by doing a pro se motion or appeal or any of those things, you are more likely to damage your case than to help it. That is just my opinion. That you are doing more harm than good, because it can get kind of sticky in there is all I'm saying. Just be careful. Go with gloves. Okay.
It can get pretty sticky in there.
So now we're going to go to the counsel filed brief, and the argument that they made was that they incorrectly used previous versions of the statute to excuse a jury member, and that I think it had something to do with the jury member either having a previous record or something like that. And at the time, in the law at the time, I think it was valid, and the trial began in 2021, and so as of the most current version, it was pertinent for that one, and it gets kind of very law-speaky statute reading. But basically what happened was they had a newer version of the statute that came into play as of August. Because his trial didn't start until December of 2021, then that was the applicable statute for those jury members. They were trying to say that they didn't apply it appropriately. The appellate court decided that they had, and that was totally fine. Now, the second error that the counsel argued in his actual counsel filed brief, I found interesting, because the jury member specifically, and they name him in the appeal. I'm not going to name him here. If you want to find out, I've got the appeal linked in the show notes. Go dig through it yourself. But what happened was the jury member, I think he was originally from Texas, and he had either been involved in the law or he had done something over there, so he kind of knew how the courts worked over there. And what happened was, when somebody explained to them their role as jury members, he was kind of confused, I guess. And so what he did was, when he went home, he went in to look and to see just the factual, like, what you're expected to do as a member of the jury. And when that didn't coincide with what he had been told, he brought that to either the clerk or to the judge's office and said, hey, this is what this says. Can I show this to the other jurors? They were immediately like, no, we're not doing that. You need to give us whatever paper you have. And then they actually pulled that specific jury member into the judge's office to kind of question him as to what he looked up. Was it information about the case, or was it just like a generic overview? And the judge found that it was not specifically to do with the case, that it was just like an overview of what you're expected to do as a juror. And they actually went on the record and talked about, you know, what your expectations are, what you can and can't do, and decided, you know, with the defendant's attorney and the defendant stuff present, they decided that it was not sufficient enough to dismiss him, and it was not sufficient enough to declare a mistrial, because when it came down to it, it didn't have anything specifically relevant to do with the case, just as to what his duties were, which technically had already been covered in court. So long and short of it, the juror was confused. He just wanted to make sure he was following the rules appropriately. He's checked that for himself, which he should not have done, rightfully. If he had any questions, if you ever serve on a jury, the best thing for you to do, if you're confused, ask the judge. That's the best thing to do.
Because I totally would have done the exact same thing.
Right, but they just want to make sure that no way of you getting any kind of bias or anything like that from outside of the case, which the only way that they can be sure of that and to be able to prove that in any kind of appeal or in court,
if you don't have any access to anything that could even
or
possibly
proof that you did. So the best case scenario, if you're ever on a jury, if you have any questions, if you're confused about anything, specifically ask the judge or the DA or somebody in the courtroom to be able to clarify that for you, because otherwise you could get a mistrial for this defendant, which means that you could end up giving this guy another chance or another go round, guilty or innocent. It's a lot. So go by what the court says, go by what the judge says, and go with that instead of doing anything on your own, because I've seen many episodes of many different crime shows that have been completely blown out of the water because one juror decided to go ask a question of somebody else or bring up something that they weren't supposed to outside of, you know, the courtroom or outside of deliberations. It's just not allowed. And that's,
don't go bringing shit up.
That's, you know, we're it's to maintain the integrity of our processes, which, we already have to rely on them and have faith in them, and knowing we have human error in all things that we do.
I feel like there's not a whole lot of integrity in some of our processes in the first place.
Exactly. That's why we're trying to keep it as clean as possible. Because it's hard enough as it is. Okay. So anyway, they argued all of that, but when it came back and when it came down to it, the appellate judges decided, this is just not enough for us to overturn, and the sentencing was all affirmed, and that just means that he's gonna stay in jail as of now. So
sorry,
he is still currently, as of this recording, at the Louisiana Department of Corrections in Angola. Everything was affirmed. He's still in jail for the foreseeable future. This was his appeal to the Third Circuit Court of Appeals, and he can appeal to the Supreme Court, but again, small percentage ever actually get heard. If on the off chance that does happen, I'll throw us another update in here. And I think that's everything for this one, guys. Thank you again so much for listening to everything, to our episodes, for sharing them with your friends, for coming back every other week or so and listening to us jabber on about these things. And us. Yeah. But I'm really excited that we've got to do 2 back-to-back now with actual appeal updates, which I find really awesome.
We've gotten 4 back-to-back.
What do you mean back-to-back? What are you talking about?
We've had 1 a week for 4 weeks.
Yes, and I just meant like 2 updates back-to-back with appeals that actually came through, which I think is really awesome. So, again, case suggestions, throw them in an email, throw them on any of the TikTok. And actually, that is interesting too. The YouTube has officially changed over now. So all of our podcasts are going directly to YouTube. So if you have YouTube Premium or anything like that, you can go and listen to them directly on there with, I guess none of the other ones really have ads either. No. But anyway, all of them are directly uploaded to YouTube now, so I don't have to do any of the version changing or whatever. So RSS straight to the YouTube.
You're great at this.
I know. And this will be our 3rd update episode. So we'll have another full episode a week from today, which is Monday. But, when this comes out, it'll be Tuesday. Whatever. Y'all have a great week. Stay warm, stay cool, stay awesome, stay cenlawsome.
Stay comfortable.
And we'll see you guys next week. See ya. Take care out there.
We better.
Bye.
This has been an elfaudio production.